Imagine for a second that you own a business, right?
Okay, I'm with you.
You spent months negotiating this crucial, complex contract with a trusted, totally independent partner.
Right.
You shake hands, sign the papers, and you feel secure knowing exactly who is in your corner.
Yeah, that's the dream, right?
Exactly. But then you wake up one morning, read the financial news, and discover your trusted partner was just swallowed up in a massive corporate merger. And they weren't just bought by anybody.
Oh, no.
Yeah, they were bought by your absolute worst enemy in the industry, like your fiercest rival.
Wow. That is a nightmare scenario.
It really is.
Yeah.
So here is the million-dollar question for you. Can you just walk away from that contract, or does the law actually force you to work with your rival's new subsidiary?
Right. That is a fantastic question.
Welcome to this deep dive. My mission today is to interrogate the facts of this exact scenario. We are going to guide our analysis, element by element, unpacking the why and how behind the law to ensure you completely master the mechanics of contract delegation.
It's a fascinating legal tightrope, honestly. And outlining the journey ahead is crucial because, well, this stuff happens in the corporate world almost every single day.
I bet.
Yeah. So the resolution to this corporate nightmare lies in the Uniform Commercial Code, or the UCC. Specifically, we're going to look at the rules regarding the assignment of rights and the delegation of duties.
Okay.
And we will examine these doctrines by dissecting the landmark 1986 Seventh Circuit case, Sally Beauty Company v. Nexxus Products.
Because when a business relationship involves both selling physical products and providing services like, say, a distributorship, where you are moving boxes of inventory but also actively marketing them, visiting salons, and, building relationships, how do you know which set of laws applies?
That is the foundational question, yeah.
Hmm.
To understand why this matters, you have to understand the purpose of the UCC.
Right.
The UCC was drafted to create standard, predictable rules for buying and selling goods across state lines, just to keep commerce flowing smoothly.
Like so.
But services, on the other hand, those are governed by the common law of individual states, which can honestly vary wildly. So to figure out which law applies to a hybrid contract, one with both goods and services, courts use what is called the dominant factor test.
The dominant factor test.
Exactly. It's a simple two-element test. Element 1. Does the transaction involve a mix of both goods and services?
Okay, assuming yes.
Right. If yes, you move to element 2. Is the essence or dominant factor of the contract the provision of goods or the provision of services?
Got it.
If the dominant factor is goods, the UCC applies. If it's services, you default to common law.
Wait, but if I'm a distributor, I might be spending millions on marketing campaigns, client relationships, and logistics, right? How do courts weigh that? Does the physical product really win out over all that specialized service?
It generally does, yes.
Really?
Yeah, I mean, in the context of distributorships, the majority rule across jurisdictions is that they are primarily treated as contracts for the sale of goods.
Wow.
The physical inventory being moved is the star of the show. The marketing, the logistics, the legwork, courts basically view all of that as merely incidental.
It's just a means to an end.
Exactly. It exists solely to facilitate the movement of the actual goods. So the UCC takes jurisdiction.
That makes sense. It's all just infrastructure to sell the widget. So assuming the UCC does apply to a contract, what is the general rule for passing off your contractual duties to someone else?
Well, the UCC fundamentally wants to encourage business, right? So it's actually quite permissive when it comes to delegating your duties to a third party.
Okay.
Under UCC Section 2210(1), the general rule is that the law sanctions the delegation of duties unless one of two specific elements is met.
And those elements are?
Element 1. The parties otherwise agreed. This simply means you put an anti-delegation clause right there in the contract.
Right. Straightforward enough.
Or element 2, the obliger, which is the legal term for the party receiving the performance, has a substantial interest in having the original promiser perform or control the acts.
Substantial interest?
Yes. If that substantial interest exists, the law says you cannot just hand your homework off to someone else.
Let me make sure I'm translating this into the real world correctly. This is like if I hire a famous, highly specific portrait painter to paint my family.
Okay, good example.
They can't just legally delegate that duty to their untalented apprentice because I have a substantial interest in the specific skills of the master painter I originally contracted with.
Exactly. You didn't just bargain for a canvas with paint on it, right? You bargained for that specific artist's talent. That is a substantial interest.
Makes perfect sense.
And when it comes to business distributorships, there's a companion rule we have to layer on top of this.
Oh, hey, Kat.
Under UCC Section 23062, if you have an exclusive dealing agreement, the law imposes an automatic implied obligation to use your best efforts to promote and sell those goods.
Best efforts.
Right. You can't just secure the exclusive rights to a territory and then, sit on your hands. You have a legal duty to actively hustle for the manufacturer.
Okay, we have the legal framework.
Yeah.
Let's analyze Sally Beauty Company v. Nexxus Products Company. First, what are the legally dispositive facts? Like, who are the actual players here and how did this corporate nightmare start?
Right. So Nexxus was a highly successful hair care manufacturer, but they had a really strict brand strategy.
Right.
They completely refused to sell their products to regular retail, grocery, or drugstores. They relied entirely on independent distributors to get their products exclusively into professional barbershops and salons.
Keeping it high end.
Exactly. So they signed an exclusive distribution agreement with a company called Best Barber and Beauty Supply to be their sole distributor in most of Texas.
Okay.
And because it was an exclusive deal, Best was legally obligated to use its best efforts to sell Nexxus products.
Right. Based on that UCC rule you just mentioned.
Spot on. So 2 years into this highly profitable relationship, Best was acquired by and merged into Sally Beauty Company. Best basically vanished as an independent entity.
Okay, but what's the problem?
Here is the massive catch. Sally Beauty was a wholly owned subsidiary of Alberto Culver.
And who is that?
Alberto Culver is a massive manufacturer of hair care products and a direct, fierce competitor to Nexxus.
Oh, wow. So Nexxus is suddenly tied to their rival.
Exactly. Upon learning that their exclusive Texas distributor was now owned by their biggest rival, Nexxus immediately canceled the agreement. And then Sally Beauty sued Nexxus for breach of contract.
And what was the core legal issue?
Simply put, can an exclusive distribution contract be delegated to a wholly owned subsidiary of a direct competitor without the obligee's consent under the UCC?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the rule based on UCC Section 2-1 combined with Section 23062.
Okay.
The rule has 3 elements. First, is the contract governed by the UCC? Second, does the contract involve a delegation of a duty to use best efforts?
Got it. And the third?
Third, does the obligee have a substantial interest in having the original promisor perform, thereby barring delegation?
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, UCC applicability? Because, like we discussed, distributing high-end salon shampoo involves a lot of relationship-building service, not just selling bottles.
Right. So to do this, the court effectively runs a mini IROC analyzing the issue, rule, application, and conclusion for this specific element.
Okay, break it down for me.
The sub-issue here is whether a distributorship agreement falls under the UCC. The sub-rule applied is the Texas dominant factor test we outlined earlier.
Because they were in Texas.
Exactly. So the court applied this by looking at Texas law. Interestingly, no prior Texas case had addressed distributorships directly.
First.
Yeah. But the court looked at the vast majority of other jurisdictions, which view the sales aspect of a distributorship as dominant over the services aspect.
Right. The inventory is the star of the show.
Precisely. The court applied that logic here. The inventory was the dominant factor, so the conclusion for the first element is easily met. It is a contract for goods governed by the UCC.
Understood. Now, what about the second element, delegation of a best efforts duty? Because I'm wondering, how exactly does a corporate merger transfer a duty? Best Barber Supply just vanished into Sally Beauty. Did Sally explicitly promise to keep trying hard, or does the law just assume the duty transfers?
That's a great question, and it's the sub-issue for our second element.
Wow.
What specific duty was delegated? The sub-rule is UCC Section 23062, which reads an implied promise of best efforts into all exclusive dealing contracts.
Okay.
The court applied the facts logically. Best was contractually obligated to use its absolute best efforts to promote Nexxus exclusively in Texas.
Right.
By merging into Sally Beauty, Best ceased to exist independently. By operation of corporate law, that exact duty of performance was mechanically delegated to Sally Beauty.
So they just inherit the duty automatically?
Yes. Sally stepped into Best's shoes. Therefore, the court concluded the second element is met. A delegation of a best efforts duty clearly occurred.
Understood. Now, what about the third element, substantial interest? This feels like the main event. How did the court decide if Nexxus actually had a valid legal reason to be terrified of their rival subsidiary?
This brings us to the most complex and critical part of the analysis. The sub-issue is whether Nexxus has a substantial interest in not accepting best efforts from Sally Beauty. The sub-rule is that delegation is barred if performance by the delegate would be a substantially different thing than what the oblige originally bargained for.
Right, substantially different.
To figure out what substantially different means in the real world, the court looked at precedent. First, they examined a Texas case called McKinney v. Milford.
What I bet there.
In that case, a contract involved a duty to provide a specific horse for breeding. The court ruled that duty was delegable.
Really? Why?
Because the third party just wanted the 2 breedings per year. It didn't matter who actually held the title to the horse. The biological result was exactly the same. The performance wasn't substantially different.
Right. Providing a horse is entirely objective, but selling professional hair care takes subjective effort.
Exactly. So the court contrasted the horse case with a federal case out of Maryland, Berliner Foods Court v. Pillsbury Co.
Okay, what was the deal there?
In that case, an exclusive distributor of Haagen-Dazs ice cream was sold to Breyers, which is, a competing ice cream manufacturer.
I see where this is going.
Yeah. The court in Berliner ruled that it defies common sense to force a manufacturer to leave the distribution of its products to a distributor controlled by a competitor.
Right, because you can't trust them.
Exactly. Distribution requires fighting for premium freezer space and grocery store placement. You cannot expect a subsidiary to fight for your freezer space at the expense of its own parent company.
So how do they apply that to Nexxus?
The Seventh Circuit applied this exact logic to Nexxus. Sally Beauty is wholly owned by Alberto Culver. Even if Sally Beauty promises up and down to be impartial and use their best efforts, they are ultimately subject to the corporate control of Nexxus's direct competitor.
Makes total sense.
Nexxus bargained for Best's undivided loyalty, not the subsidiary of a rival. The court concluded that element 3 is definitively met. Nexxus has a substantial interest in not seeing this contract performed by Sally Beauty.
And after analyzing all the elements, what was the court's final conclusion?
Synthesizing all of that, because all 3 elements are met, the court concluded the duty is per se non-delegable. Yeah, the Seventh Circuit affirmed the summary judgment in favor of Nexxus, formally holding that the duty of performance under an exclusive distributorship may not be delegated to a wholly owned subsidiary of a direct competitor without the obligee's consent.
Okay, but I have to push back here, because this was not a unanimous decision. And this is where the law hits the reality of modern commerce.
That's right.
Judge Richard Posner, who is famous for applying economics to law, wrote a scathing dissent. Honestly, his view of the facts makes you question the majority's entire premise.
He definitely didn't hold back.
Isn't the majority taking an overly simplistic, almost naive view of how modern conglomerates work? I mean, Posner points out that Sally Beauty is a multi-line distributor.
Right.
They don't just sell Alberto Culver stuff, they sell Revlon, Clairol, L'Oreal. If Alberto Culver actually forced Sally Beauty to sabotage Nexxus to boost their own cheaper products, wouldn't Sally Beauty instantly lose all those other massive clients?
It would be bad for business.
It would be a commercial disaster for them to show favoritism. Plus, doesn't Alberto Culver doing that risk a massive antitrust violation under Section 2 of the Sherman Act by trying to monopolize the market through distribution sabotage?
Yep, that's a huge risk.
It just seems highly improbable that a parent company would destroy its own profitable subsidiary just to spite one rival.
It is a brilliant piece of legal and economic pushback by Judge Posner, and it highlights why these cases are so heavily debated. He unpacks this by arguing that the majority confused a legal conflict of interest with a business conflict of interest.
Oh, that's the difference.
In law, a conflict is fatal. A lawyer absolutely cannot represent 2 opposing clients in the same case. The system forbids it.
Right.
But Posner notes that in business, structural conflicts are incredibly commonplace. He uses the example of General Motors selling Isuzu cars, which is a direct competitor.
Oh, right. That happens all the time.
Or steel companies that sell raw steel to competing fabricators. Best was not a fiduciary of Nexxus. They were just a business partner.
So he thinks the risk was exaggerated.
Exactly. Posner argues that the financial incentive for Alberto Culver to destroy Nexxus via Sally Beauty is practically zero. Any trivial gain in Alberto Culver sales would be entirely eclipsed by the utter destruction of Sally Beauty's reputation as a reliable, neutral distributor for the rest of the industry.
Exactly. So if Posner thinks the majority got the business reality wrong, what was his proposed legal remedy? because Nexxus was clearly freaked out, and maybe rightfully so, even if a deliberate corporate sabotage campaign was unlikely.
Well, Posner points to an alternative, much more nuanced rule within the UCC. He explains that if Nexxus was worried about Sally Beauty's performance, the proper legal procedure wasn't to just tear up the contract and walk away on day one.
What should they have done?
Under UCC Section 2609, if a party has reasonable grounds for insecurity, they have the right to demand assurances of due performance in writing.
Assurances.
Yes. Posner argued that Nexxus should have gone to Sally Beauty and said, "Prove to us how you will maintain your best efforts and protect our trade secrets despite your new parent company."
Give them a chance to explain.
Exactly. If Sally Beauty failed to provide adequate assurances, then Nexxus could cancel. Because Nexxus never demanded those assurances and just outright canceled the deal, Posner argued that granting summary judgment was wrong. He believed the case needed to go to a full trial to see if the merger actually made Sally Beauty unable to perform.
That makes total sense from an economic standpoint.
Mm-hmm.
But I also see the visceral protective reaction the majority had. Let me give you an unforgettable hypothetical to really cement this substantial interest rule for you, to show why sometimes you just can't stomach a new partner.
Okay, let's hear it.
Imagine you own an ultra-exclusive, pristine, holistic, vegan health retreat. People pay thousands of dollars to come cleanse their bodies. You sign an exclusive multi-year contract with a world-renowned, fiercely dedicated vegan chef to provide all the meals.
Okay, setting the scene.
A year later, that chef's LLC is bought out in a hostile takeover by Mega Slaughter, Inc. Yeah, a massive industrial meatpacking corporation famous for its gruesome factory farming. Mega Slaughter delegates the cooking duties to their newly acquired subsidiary, promising you, hey, don't worry, the meals will still technically be vegan.
That is a phenomenal, if slightly horrifying example.
Right.
And it perfectly illustrates the analysis of why the majority ruled the way they did. Under UCC Section 2210, you are the obligé. Do you have a substantial interest in not having your vegan retreats meals provided by a meatpacking conglomerate's subsidiary?
I would say absolutely.
Absolutely. Just like Nexxus, the risk of compromised best efforts is just one part of it. The visceral destruction of the bargain for brand alignment means that performance by the delegate is a substantially different thing than what you agreed to.
The vibes are completely ruined.
Completely ruined. The delegation is entirely barred. You bargained for a dedicated vegan chef, not the side project of a slaughterhouse.
So we've walked through the rules, the case, the dissent, and the hypotheticals. How do we put this all together? When someone is staring down a massive corporate merger of their partner, what exactly should they do?
We can synthesize this entire module into an actionable, step-by-step diagnostic checklist.
Perfect.
Whether you are issue spotting on a law exam or navigating a real-world corporate curveball, here are the 5 steps to analyze delegation.
Hit me with step 1.
Step 1. Identify the governing law. Apply the dominant factor test. Look at the core of the contract. Are goods the essence of the deal? If yes, you trigger the UCC, even if services are attached.
Okay, got it. What's next?
Step 2. Spot the delegation. Did a party attempt to transfer their duty of performance to a third party? A corporate merger that absorbs your partner qualifies.
Right, like Best vanishing into Sally Beauty. Step 3.
Step 3. Check for best efforts. Is it an exclusive dealing contract? If so, UCC Section 23062 automatically implies a strict duty of best efforts.
That implied hustle. Okay, step 4.
Step 4. Analyze substantial interest. This is the ultimate deal breaker. Would performance by the new delegate be a substantially different thing?
Like the vegan chef and the meat packer.
Exactly. Look for direct competitors, wholly owned subsidiaries of rivals, or fundamentally incompatible business practices. If yes, the delegation is invalid without your consent.
And the final step.
Step 5. Consider alternative remedies. If the risk is merely insecurity rather than a direct competitor takeover, say, a key employee left, but it's not a rival company, did the obliged demand written assurances under UCC Section 2609 before repudiating the contract? Always check if they ask for proof first.
It's incredible how much weight a single legal phrase like substantial interest carries when millions of dollars and corporate empires are on the line. And it brings us right back to where we started.
It really does.
With massive corporate conglomerates gobbling up independent businesses every single day, the landscape of who actually owns who is constantly shifting. How many exclusive contracts out there are currently hovering right on the edge of becoming legally void because of a quiet acquisition? The next time you sign an agreement with a trusted independent partner, ask yourself, who are you really going to be doing business with tomorrow?